There is a bail spree at the Supreme Court of India. After successfully arresting and incarcerating several opposition leaders before the 2024 general elections, Prime Minister Narendra Modi's NDA government is now having a very difficult time retaining them in jail. The Supreme Court has not just released some of these tall leaders like Delhi's Deputy Chief Minister Manish Sisodia and Telangana's BRS party leader Kavitha on bail, but also diluted to a little extent the draconian PMLA and UAPA. You would know that these special laws make bail extremely difficult to get. What we will all find interesting to note is that the judgments in most of these bail cases have mostly come from one particular bench of the Supreme Court, that led by Justice BR Gavai and consisting of Justice KV Vishwanath. This bench has also made scathing remarks against government's agencies like the ED for being picky and also questioned its impartiality. Bail is the rule, jail is the exception has again been reiterated, but the question is whether anyone is listening. Anyone in the judiciary, other benches of the Supreme Court, the High Courts, and especially the district courts listening? It's not as though the Supreme Court is saying this for the very first time, yet bail is very frequently rejected. Evidence of this are the overcrowded prisons in India. In this episode of the Justice Brief, we will quickly look at these latest political developments and the progressive bail judgments, and also, more importantly, we'll look at how such progressive judgments were perhaps not applied or ignored in many cases. In Sisodia's case, the Supreme Court granted him bail owing to his prolonged incarceration of 17 months. Justice Gavai's bench said that due to 495 witnesses and thousands of documents running into lakhs of pages, there was not even the remotest possibility of trial being completed. So keeping him in jail in the hope of trial being completed would be a grave violation of his fundamental right to personal liberty. Justice Gavai's bench found fault with Delhi High Court's order denying him bail, stating that it did not consider the aspect of delay in trial. You know, it is interesting that Justice Gavai said this because last year in October, another Supreme Court bench led by Justice Sanjeev Khanna had rejected Sisodia's bail plea. That bench had said that Sisodia can again apply for bail in 3 months if the trial progresses very slowly. 9 months passed and now another bench says that there is not even remotest possibility of trial starting anytime soon. Anyone who knows about how the Indian judicial system functions would surely know that the trial finishing in 3 months in a case with 500 witnesses and lakhs of pages of documents is a joke. Surely, Justice Khanna, in line to be the next Chief Justice of India, knows that too. So why did he deny bail to Sisodia when his bench heard the case? Maybe some reasoning ought to come from the Supreme Court on this aspect as well. In Kavitha's case this month, the Supreme Court bench of Justices Gavai and Vishwanathan granted her bail after observing that the PMLA Section 45 mandates courts to be more sensitive and sympathetic towards certain categories of persons like those under 16, women, infirmed, etc. The law requires this because these categories of people might be made scapegoats by the real guilty. However, the Delhi High Court had refused Kavitha this special treatment. Justice Swarnakanta Sharma had said that Kavitha, being highly qualified and a well-accomplished person, is not a vulnerable woman. The Supreme Court took strong exception to this observation, stating it was erroneous and even orally observed was perverse. Even otherwise, the CBI and ED have filed their charge sheets and Kavitha's custody is no longer required for investigation. She has already spent 5 months in jail and the trial, like in Sisodia's case, would not begin anytime soon. Most important observation was that the fundamental right of personal liberty provided under Article 21 of the Indian Constitution is superior to any stringent provisions of any law that makes bail very difficult. During the hearing, Justice Gavai had also questioned the ED and CBI's fairness. Prosecution has to be fair, a person who incriminates himself has been made a witness. Tomorrow you pick up anyone as you please and leave anyone as you choose. You cannot pick and choose any accused. What is this fairness? Justice Gavai commented. Is anyone listening at the ED office, at the CBI's office? If not, what does the Supreme Court plan to do? Shouldn't there be some accountability of those who violate this? Moving on to Prem Prakash's case, Prakash is apparently Jharkhand Chief Minister Hemant Soren's close aide and is accused in an illegal mining scam. The same bench at the Supreme Court held that even in money laundering case, bail is the rule and jail is the exception. This is a good development since there was a growing perception that the reverse is true under PMLA and UAPA. The Madras High Court had said that jail is the rule under PMLA back in February this year. The Supreme Court too seemed to add fuel to the fire when it said the same thing in a UAPA case the same month. It was important therefore that the highest court of the land nipped such assumptions in the bud. Most important takeaway from Prem Prakash's case is this. The Supreme Court has come up with 3 foundational facts that the state has to establish when opposing a bail plea of an accused under PMLA. This would therefore help bring greater clarity in the bail proceeding and help a court to decide the bail plea. Like I pointed out previously, all these judgments have come from the same bench. The problem comes when another bench or courts below still choose to ignore such rulings. Remember, when it comes to bail, it is discretionary. That you ought to get bail is not a matter of right in non-bailable offences. Rape, murder, serious offences are usually non-bailable offences. Only a court can grant bail in non-bailable cases. A judge has discretion to decide whether to allow or reject bail in such cases. Depending on the gravity of the offence, on whether the accused is flight risk, possibility of evidence tampering, and criminal history, a judge may reject or grant bail. But although the judge has his discretion, exercise of such discretion is not absolute, in the sense that it must be exercised within the framework of the law and in line with established judicial principles, precedents. Bail is the rule, jail is the exception is a judicial philosophy, jurisprudence that Indian courts ought to follow. If the accused is unlikely to flee and can be expected to stand trial when the time comes, the judge is expected to grant bail. However, judges at the lower courts are hesitant to grant bail due to various reasons. Conservative thinking, fear of complaints for being too liberal, fear that higher court judges may pass adverse remarks against them, playing it safe, etc. are some of the reasons. Naturally, higher court judges vent out their frustration sometimes in open court and sometimes in their speeches because they have to sit on so many simple bail applications. Ultimately, everything ends up at the higher courts. Should not the Supreme Court see who is complaining against judges granting bail? What system is in place to avoid this?
I urge everyone on the dais to urgently address the persistent issues being faced by judges of the trial and district and session courts, who are the backbone of our judicial system. It is time for us to make our justice delivery system more efficient, stronger and viable.
Now, this is one aspect. The other aspect is how cases which receive so much publicity are dealt by the higher courts themselves. For example, after 3 rounds of litigation, Sisodia was granted bail. The facts of the matter remained the same. Only the time period of incarceration had increased. Much criticism of the court therefore comes when different benches decide very differently on the same set of facts in the same court. And then the Supreme Court blames the High Court for playing it safe and denying Sisodia bail. Supreme Court says that High Courts routinely deny bail in criminal cases instead of granting bail as the norm. So when such mixed signals come from the highest court of the land, what happens at the lower levels in cases that no one talks of? I looked at 10 bail cases that from around the time the Supreme Court was making these pronouncements. They concerned UAPA, PMLA and other special laws and regular IPC sections. I found that in all these cases, the philosophy extended by the Supreme Court did not seem to apply. While the Supreme Court has now ruled that bail is the rule even in PMLA cases, in February it ruled that bail is the exception and jail is the rule in UAPA cases. This was in the case of Gurvinder Singh, a man who was charged for allegedly promoting Khalistani terror movement. In April, relying on this judgment, the Delhi High Court denied bail to one Jamshed Zahur Paul, who has been in custody for 4 years on terrorism charges under UAPA. The trial hadn't even commenced, yet bail was denied. By this time, the Supreme Court had granted bail to people due to delay in trial. If you look at district courts, a court in Bastar district of Chhattisgarh denied bail to human rights activist Lakhma Ram Koram, who who was arrested on Naxalite charges in December last year. The district court in August this year simply noted that the charges under UAPA and IPC are serious and therefore it does not seem appropriate to give the benefit of bail. This is despite the police already completing its investigation and filing a charge sheet. The Supreme Court's judgments on delay in trial etc. did not come of any use at the grassroots level. If you look at other types of cases like a conversion offence from Uttar Pradesh, you will note how certain judges of high courts look at everything except the bail jurisprudence. An accused named Kailash was charged under IPC and UP Prohibition of Unlawful Conversion of Religion Act 2021 for allegedly converting someone to Christianity. The Allahabad High Court's bail order noted that religious congregations where conversions take place should be stopped immediately, or the country's majority population will become a minority one day. Even though no offence was established and the trial not having commenced, the High Court declined the bail application on the ground that the alleged offence was a very serious offence. Couple of days after this bail order was passed, the Supreme Court in a different case said that the criminal jurisprudence, the philosophy that an accused is presumed to be innocent until proven guilty, cannot be brushed aside lightly, however stringent the penal law may be. Do you see the clear contradictions now? In another case from August, where the Delhi High Court had stayed the grant of bail for over 1 year without giving any reasons, the Supreme Court said this power to stay bail order should be exercised sparingly and only in exceptional cases. But in September last year, the same Supreme Court stayed a Bombay High Court order granting bail to Bhima Koregaon accused Mahesh Raut. And hence, a huge criticism of the court has been that different benches take diametrically opposite views on similar questions of law and facts of the case, and the lower courts get mixed signals and are hesitant to grant bail as a result. Justice comes not from a steady body of law but depends on which bench consists of which judge. The Supreme Court thankfully continues to police and rectify some judgments of courts below. But remember that access to justice in this country is not so great. Many find it extremely difficult to make it to the Supreme Court or even the High Court for that matter. There has to be some disincentive for the judges to not violate what the Supreme Court repeatedly says on grant of bail. Why can't there be something as simple as a data library on which judge is granting or rejecting how many bails after how many months? Else, we might only hear bail is the rule, jail is the exception in some high-profile cases every now and then, but it would really mean nothing for the common man.